Okay. Well, hi everyone. For those of you who don't know me, I'm Romany Webb. I'm the Deputy Director of the Sabin Center for Climate Change Law at Columbia University. And on behalf of the center, I'm pleased to be able to welcome you to this webinar on climate governance under the London Convention and Protocol. As we'll talk about today, the international regime established via the London Convention and Protocol has played a really key role in regulating climate-related activities in the ocean, particularly activities that seek to store carbon in the ocean. And that's something that governments and others around the world have been looking at for several years now. The primary focus initially was on the potential for sub-seabed storage of carbon dioxide captured on land at industrial facilities and power plants and the like. Recently, though, a range of other approaches have been proposed that seek to use the ocean to uptake and store carbon dioxide directly from the atmosphere. You can see some of them on the graphic on the right of this slide. These are often referred to collectively as marine carbon dioxide removal or mCDR approaches, and they include things like ocean fertilization, ocean alkalinity enhancement, and seaweed cultivation and sinking, among others. Today, we're going to talk about how these sorts of activities are currently governed under the London Convention and London Protocol, and how that governance might evolve in the future. And we have three leading experts with us who are going to discuss possible future directions for governance. Before we get to that, though, I am going to kick us off with some background on the London Convention and Protocol, what they say, their purpose and goals, and how they've been applied to carbon storage activities in the ocean previously. I am going to move through this pretty quickly, but if there are questions that come up, please put them in the Q&A box in the Zoom, and we'll try to get to them at the end. So the London Convention and Protocol are two separate but related international legal instruments that seek to control ocean dumping. The London Convention was adopted first in 1972, and it was actually one of the first international agreements that sought to protect the marine environment from human activities. So you see here in the preamble to the convention, there is a recognition of the vital importance of the marine environment, also of the fact that that marine environment is under threat from pollution, particularly pollution due to the dumping of waste. And so in this convention, the international community agreed to take urgent action to control that pollution due to dumping. At the time the London Convention was adopted in the 1970s, the international community was especially concerned about the dumping of radioactive waste and other forms of industrial waste, for example, from oil and gas operations. And so the convention was really designed to limit that. As you can see here, it requires parties to take all practicable steps to prevent the pollution of the sea by the dumping of waste or other matter. So that's the convention. Where does the protocol come in? In the 1990s, there was an effort to update and really strengthen international regulation of dumping. And so as you can see here, there was a view that more stringent measures were needed to prevent and really eliminate marine pollution from dumping. And so those measures are set out in the London Protocol, which was adopted in 1996. It's important to understand that the protocol is a standalone, self-contained legal instrument. The protocol does not, for example, amend the London Convention. It is actually intended to wholly replace the convention. Before that can happen, though, all of the parties to the London Convention must sign on to the London Protocol, and several of them have yet to do so. And so as a result, the two instruments, the London Convention and the London Protocol, currently operate in parallel. They impose similar but notably different requirements. Which requirements apply to which country depends on whether the country is a party to the London Convention or the London Protocol. So as an example, here in the United States, the US is a party to the London Convention, but has not ratified the London Protocol. And so it is bound only by the convention. Other countries like Australia, Canada, Germany, and others have ratified both the convention and the protocol. And so for those countries, the London Protocol effectively supersedes the convention and they are bound by the protocol. The London Protocol sets somewhat more ambitious goals for ocean protection, and so is somewhat more restrictive of dumping than the London Convention. And you see here in Article 2, the parties to the London Protocol commit to take measures to prevent, reduce, and where practicable, eliminate pollution caused by dumping. So what counts as dumping? The London Convention and Protocol both define dumping broadly to include any deliberate disposal at sea of waste or other matter. The London Protocol also expressly includes within the definition of dumping the storage of waste or other matter in the seabed. And so as I'll talk about in a minute, that's important for projects that involve sub-seabed storage of carbon dioxide. Those projects clearly fall within this definition of dumping. So the next question is, how is dumping regulated under the London Convention and Protocol? Both instruments require parties to adopt domestic regimes to control dumping. Basically, they both say that parties must require dumping to be permitted, and they establish rules for when parties can issue permits. The London Convention is, as I said before, more permissive. So parties to the London Convention can permit the dumping of any waste or other matter unless it is specifically listed in Annex 1 to the Convention. And so that annex includes 8 blacklisted substances, you see them on the left here, for which permits cannot be issued. The London Protocol adopts really the opposite approach. It adopts what's called a reverse listing approach, under which parties can only issue permits cannot issue permits for the dumping of any substance unless it is specifically listed, again, in an annex. One thing to note here is that permits for dumping are issued at the national level. I often hear people suggest that there is some international permitting of dumping, that some international body like the IMO or some other body issues permits for dumping. That is not the case. Dumping is permitted at the national level by the country under whose jurisdiction or control it occurs. And that's true even for projects on the high seas. So what does all of this mean for activities involving the storage of carbon dioxide in the ocean? Well, you see here the list of substances that can be dumped with a permit under the London Protocol expressly includes carbon dioxide streams from carbon dioxide capture processes for sequestration. This actually wasn't in the original version of the London Protocol that was adopted in 1996. So under the structure of the London Protocol, parties originally could not issue permits for sub-seabed carbon storage. In the 2000s, though, several countries were interested in pursuing sub-seabed carbon storage as part of their climate mitigation efforts. The thinking was that parties could capture carbon dioxide at, say, industrial facilities and inject it into sub-seabed geologic formations to prevent it entering the atmosphere. In 2006, the parties agreed to amend the London Protocol to enable this type of sub-seabed carbon storage based primarily on its climate benefits. So you see at the top of this slide an extract from a report on the 2006 meeting of the parties to the London Convention and Protocol, at which the parties recognized that sub-seabed carbon storage could have a role to play in addressing climate change, and they agreed to consider how best to facilitate and regulate this activity under the Convention and Protocol. And it was at this 2006 meeting that the parties agreed to amend the protocol to authorize sub-seabed carbon storage with a permit. The parties to the London Protocol adopted another amendment in 2009 to enable countries to export carbon dioxide to other countries for sub-seabed storage there. That 2009 amendment actually hasn't formally entered into force, but it is being provisionally applied. And that has enabled projects like the one you see at the bottom of this slide, the Northern Lights project in Norway, which is receiving carbon dioxide from other parts of Europe and injecting it into sub-seabed geologic formations about 100 kilometers off the coast. Now, whereas the parties to the London Protocol have sought to facilitate this sort of sub-seabed carbon storage, They have taken a somewhat more restrictive approach to other climate-related activities, including mCDR activities that seek to uptake and store carbon dioxide from the atmosphere in the ocean. The parties have been discussing mCDR since the mid 2000s, and initially they focused on one specific mCDR approach called ocean fertilization, which involves adding iron or other nutrients to ocean waters with the goal of stimulating phytoplankton growth. The discussions of ocean fertilization were prompted initially by a proposed commercial project. In 2007, a US-based company called Planktos proposed to discharge iron into ocean waters off the coast of the Galapagos Islands for the stated purpose of generating carbon credits for sale. That project ultimately did not go ahead, but it did generate a lot of discussion at the international level and domestically in many countries around ocean fertilization. The US actually referred the Planktos proposal to the scientific groups of the London Convention and Protocol and requested their advice on it. The scientific groups responded by issuing a statement of concern, which indicated that, and I quote, "Ocean fertilization remains largely speculative, and many of its environmental side effects have yet to be assessed." End quote. The scientific groups thus recommended that any proposed ocean fertilization activities be evaluated carefully to ensure that they are consistent with the objectives of the London Convention and Protocol. The parties took note of that and in 2008 issued a resolution that sought to restrict ocean fertilization activities, and there was some follow-up activity in 2010. I'll come back to that in a minute. Despite the parties saying in 2008 that ocean fertilization activities should be restricted, in 2012 there was an unsanctioned project that occurred off the coast of Canada, and that prompted the parties to again look at ocean fertilization. And this time the parties to the London Protocol adopted an amendment dealing with ocean fertilization. So I want to spend just a couple of minutes now digging into some of the details of these different actions. First, the 2008 resolution. This was a resolution jointly adopted by the parties to both the London Convention and the London Protocol. It is not legally binding, but it does carry significant weight. In this instrument, the parties stated that the scope of the London Convention and Protocol includes ocean fertilization, so that activity can be regulated under these instruments. The 2008 resolution draws a distinction between ocean fertilization research and non-research activities. The parties basically agreed that activities that involve what they describe as legitimate scientific research should be allowed, at least in some cases, but other activities, deployment activities, should not move forward. This approach of distinguishing between research and deployment does, I think, in many ways make sense. There is certainly a need for more research into ocean fertilization, so why not allow that while restricting deployment? The challenge, or one challenge, is really how to distinguish research from deployment. The parties to the London Convention and Protocol have tried to provide some guidance on that. So in 2010, they issued an assessment framework for evaluating proposed ocean fertilization research projects. And this assessment framework provides, broadly speaking, for a two-stage review. First, there is an initial assessment, which looks at whether a project has proper scientific attributes to be considered legitimate scientific research. If it does, the review then moves into a second stage, which involves an environmental assessment. And after that, the party under whose jurisdiction or control the project occurs must make a decision about whether to allow it or not. The framework says that activities should only be allowed if conditions are in place to ensure that, as far as practicable, environmental disturbance and detriment would be minimized and scientific benefits maximized. And projects that are deemed to present sort of unacceptable risks or uncertainties should not go ahead. Now, like the 2008 resolution, this assessment framework isn't legally binding. And you can see here it uses fairly soft language. It states, for example, that the parties should act in certain ways, but it doesn't require them to do that. The parties to the London Protocol later sought to formalize this approach and give it legal force and effect through an amendment to the protocol. This amendment was adopted in 2013, but is yet to enter into force. It is an amendment, as I said, to the London Protocol. It does not change the convention. And so even after it enters into force, this amendment will only bind parties to the London Protocol and not the convention. And it is worth noting that a relatively small number of countries are actually party to the protocol. It's somewhere, but I think it's around 55 or 56. So this will not, even after it enters into force, create a truly sort of global governance regime for mCDR. But it is still very significant and important. So I want to talk a little bit about what it says. You see here, the amendment prevents parties to the London Protocol authorizing the placement of matter in the ocean in connection with a marine geoengineering activity listed in Annex 4, unless the listing provides that the activity may be authorized under a permit. That's quite a mouthful. So if we break this down, we're talking here about activities involving the placement of matter into the ocean, but only for marine geoengineering activities. You see here that marine geoengineering is defined broadly, but again, there is a limit because the amendment only applies to marine geoengineering activities that have been listed in Annex 4. Annex 4 currently only lists ocean fertilization, and it says that activities involving legitimate scientific research may be permitted, but other ocean fertilization activities are prohibited. Well, this 2013 amendment only currently applies to ocean fertilization. Over the last few years, the parties have been talking about possibly listing additional activities. That hasn't happened, but in October of 2023, the parties did issue this statement on marine geoengineering, in which they said basically that they think certain other mCDR activities should be treated similarly to ocean fertilization. They looked specifically at ocean alkalinity enhancement and biomass sinking, and they said that for both activities, it may be appropriate to allow some research, but deployment should be prohibited at this stage. And they said that the assessment framework for ocean fertilization could be used for these other activities. There has since been an effort to develop specific assessment frameworks for ocean alkalinity enhancement and biomass sinking projects. That's still underway. The parties continued their discussions of mCDR at last year's meeting. And as you see here, they emphasized the need to take a precautionary approach to these activities, but did not sort of take further action. This statement and the one that was issued in 2023 are again not legally binding. So even though the parties to the London Convention and Protocol have been working to develop really a global governance framework for mCDR since the mid-2000s, we still don't have a binding set of rules for this rapidly growing field. And that is, I think, a real issue. So how do we address it? To discuss that, we have three experts with us. First, my Sabin Center colleague, Corey Silverman-Rolati, who's a senior fellow in our carbon management and negative emissions program. We also have with us Lena Rochelle, who's a scientific researcher at the Research Institute for Sustainability in Germany, and John Mimikakis, who is Vice President for Ocean Climate Innovation at the Environmental Defense Fund. And it's a great time to be hearing from these three about what future governance of mCDR may look like under the London Convention and Protocol, because as some of you may know, the parties to those agreements will be convening for their annual meeting in just over a week, and mCDR is on the agenda. So I want to kick off with an opening question for our three panelists to enable us to know a little bit more about you. Tell us how you came to work on mCDR and what the primary focus of your work in that space is. Maybe we can start with John and then go to Corey and Lena.
Sure. Thanks so much, Ramani, and thanks for that great overview and presentation. Uh, you're probably familiar with Jane Lubchenco. She's one of the world's great ocean champions. She's one of my personal heroes and mentors. And a little while ago, she asked me to come work for her in the last U.S. administration, the Biden administration, at the White House Office of Science and Technology Policy. So Jane is famous, I think, for first saying that the ocean's not merely a victim of climate change, but an important source of solutions. And she helped develop the Ocean Climate Action Plan that the U.S. administration published a couple of years ago. And so we put together a team to develop the U.S.'s first national marine CDR research strategy. So we built a team of experts across more than 17 agencies, wrestled with a lot of these issues, and published the U.S.'s first strategy, maybe the world's first marine carbon dioxide research strategy. And that's how I got into this originally. Since then, at EDF, we've been starting to engage in some of the governance issues. We'll be attending the London Convention and Protocol meetings in a couple of weeks. We've been engaging at the IPCC. We've been talking to voluntary carbon market regulators. We've been exploring community engagement, and we've been engaging on the science, consulting and pulling together scientists to really try to understand deeply these different approaches and the potential risks they pose.
Thanks, Corey.
Thanks, Romany. Glad to be here. So I joined the Sabin Center back in 2020, and pretty quickly after I joined, we started a now long-running research project mapping and analyzing the legal framework that applies to marine carbon removal activities. So we've been analyzing both U.S. domestic law and international law, which is relevant here with the London Convention and Protocol. And the way we've done so is through a series of blog posts and white papers, and specifically we've published white papers on specific mCDR approaches, including ocean fertilization, artificial upwelling, seaweed cultivation, and ocean alkalinity enhancement. In addition to those sort of white paper pieces, we've also published a book analyzing domestic legal frameworks that are applicable across seven different countries around the world. And we've also done some thinking around the potential for legal change within this space. So within the US space, we've discussed both executive actions that federal agencies within the US could take and potential model federal legislation to develop a new legislative framework for the permitting and governance of these activities to ensure that they go forward in a safe and responsible manner. Since then, we've sort of expanded our research into distinct legal issues like liability for these projects, for the potential environmental harms that these projects could bring. We've done more analysis of specific US state level policy and law that could apply here. And we're expanding our work into the international legal frameworks. And just a couple months ago, published a white paper on international legal guidelines that should apply for the governance of mCDR activities, specifically under the London Convention and Protocol. So that's sort of the background of our research here.
Great, thanks, Corey. Lena?
Yes, thanks also from my side for hosting this webinar and the great introduction, Romany. So I'm part of the Ocean Governance Research Group at the Research Institute for Sustainability in Potsdam in Germany since 2020. And as part of the Ocean Governance Research Group, we look at all kinds of emerging governance issues within the ocean, may that be plastics or climate or deep seabed mining. And I came to the topic of mCDR through a large EU-funded project called Ocean Nets. And that was really the first of its kind that looked at both the scientific side of mCDR as well as the social, economic, policy, governance aspects altogether. For the EU to make decisions based on a wide range of considerations. And so within that project, we put forward a good governance framework for mCDR. We've published a policy brief, but we also published in scientific journals our findings on the system-aware approach to governance.
Great, thank you. And Lena, I want to stay with you and ask you a question. Governing an activity like mCDR necessarily involves trade-offs, for example, between local environmental protection and climate change mitigation. And so can you speak a bit about how, in your view, the London Convention and Protocol have approached this trade-off in the context of mCDR to date, and how they might treat it in future governance?
Yeah, so that's really one of the central tensions to governing mCDRs, this duality in the environmental mandate. So on the one hand, we have this global imperative to reduce the atmospheric CO2, and on the other hand, there's the obligation to protect the ocean ecosystems from harm. And these objects aren't just competing with one another, they really interact with one another in a complex and sometimes even a paradoxical way, because some mCDR approaches even have other effects that might be positive for the marine environment, such as reducing ocean acidification. So that might be a co-benefit. Other side effects may be an impact on food systems, creating new risks for the marine environment beyond potential pollution. And now that creates a governance dilemma, how to weigh these long-term diffuse global benefits for the climate against immediate environmental risks. And the LCLP really has a clear and quite narrow mandate to prevent pollution to the marine environment. And so decisions under LCLP are risk-based and they have a precautionary lens. And so far, LCLP has not really engaged in balancing trade-offs. And there's really not a mechanism to do so, even though there has been an understanding in recent years that would be necessary to holistically approach the topic. What we do see is in the assessment framework that GISAMP is putting forward, that there is a range of indicators present that include ecologic, climatic, socioeconomic parameters that to judge if a research project is worth going forward. So that is a way to showcase the different considerations, even though it's not really a way to balance the trade-offs. So in my view, LCLP will continue to be in this gatekeeper function to protect the ocean and not really weigh the marine risks against global climate benefits, but the assessments made under LCLP can inform a broader governance process and processes that are equipped to consider such trade-offs. And perhaps it's even better to shift from trade-offs that need to be managed to having LCLP really contribute to a governance system that needs to be coordinated with the different objectives that we have for the environment. And that would require bridging across institutions that have different objectives and treat these objectives as interdependencies rather than opposing and clashing.
Yeah, it's a really good point. We've been focused in on sort of one international legal regime that's relevant in this space, but there's lots of other international agreements and rules of customary international law that also have implications here. And so thinking about how to harmonize across them is going to be really important as we move forward. So Corey, a question for you that's sort of related to that point. In other treaty regimes, these sorts of environmental trade-offs have often been managed by applying the precautionary principle, which tells countries that scientific uncertainty should not be used as an excuse to delay environmentally protective action. Can you say a bit more about that principle, whether it's the right framework to apply in the mCDR context, and how sort of the parties to the London Convention and Protocol have been applying it to date?
Yeah, thanks for that question. I think this dovetails nicely on the comments Lena was making. So the precautionary approach is a long-running, important guideline within international law. And as you rightly said, stands for this proposition that we shouldn't delay environmentally protective actions in the face of scientific uncertainty where there's the risk of serious or irreversible harm. So in our white paper where we analyze the precautionary approach and its application to mCDR under these treaties, we came away with two sort of conclusions of how parties can think about this approach going forward. One is that parties should apply the full dimension of the precautionary approach. And what we mean by that is both applying the precautionary approach to protection from ocean harms within the ocean and applying it to protect the ocean from the impacts of climate change. So in past discussions and in that presentation that you laid out, Romani, I think you laid out how parties have correctly applied the precautionary approach to protect the ocean from the potential harms of ocean iron fertilization activities. But in applying the full dimension of the precautionary approach, parties can also, not delay potential actions to protect the ocean from climate change. And in doing so, they can develop this sort of balanced trade-off framework that Lena discussed, where you try to weigh the different aspects of climate harm and environmental harm. So in our paper, we sort of analyze a way when you can more fully analyze the approach to where it's not just talking about distinct harms to the ocean from these activities, but is also considering the impact that climate change can have on the ocean. And in recent international jurisprudence, we have really clear articulated principles that international courts have said that climate change poses serious and irreversible risk of damage to the oceans itself. The second point that I'll try to make quickly here is that the precautionary approach is not the only guideline that is relevant to the governance of mCDR activities under these treaties. And in our paper, we analyze 3 other guidelines that are really relevant here: prevention of transboundary harm, due diligence, and environmental impact assessment guidelines. And one key point I'll hone in on here is that prevention of transboundary harm is a key principle relevant to all environmental governments. It's a customary rule of international law, and really grappling with what that principle means for the governance of mCDR under these treaties is a key thing that parties will need to be discussing.
Great, thank you, Corey. I want to turn to you now, John. So you work in an environmental NGO, EDF, Environmental Defense Fund, and groups like that I think are increasingly interested in engaging in mCDR governance discussions like those at the London Convention and Protocol. Can you say a bit about how the NGO community or EDF specifically is thinking about this balance of sort of environmental protection and climate mitigation and those sort of competing interests?
Sure, thanks, Romani. So this is really tough. I mean, EDF and many NGOs have worked collaboratively with coastal communities around the world on ocean conservation, right? We've spent millions of dollars of government and philanthropic funding to promote sustainability. People have spent whole careers, the number of hours have been countless. And will this all be for naught? I mean, this is one of the big threats that, climate change really is an existential threat to the health of the ocean, right? The IPCC has told us that if average temperatures rise by 2 degrees, more than 99% of all the coral reefs could disappear. And, you're talking about, and I think earlier this week or last week, there was a report about how we may have passed a tipping point already with regard to the health of coral reefs. You're talking about critical ecosystems that billions of people rely on for food, livelihoods, and cultural identity. This is really enormous. So we're really being forced to deal with this. We would like to see that emission reductions would tackle this problem, but the IPCC has told us that the need for removals is unavoidable. So we're trying to grapple with how to reconcile these tensions. I think that we're trying to think about this in terms of if we need CDR, we recognize that many types of CDR, not just marine CDR, are still in development, right? Marine CDR is no different. And many people we recognize are excited about marine CDR because the ocean has so much potential capacity to absorb CO2. However, while we've learned a lot about marine CDR, there are still many critical unanswered questions about its effectiveness, about its impact on the environment and scalability. And so obviously there's an enormous need for research. We think that the level of support for research is not proportionate to the urgency with which we need to answer these questions. So we think we need much more support for research. And we think that while the research is being done, that we need to make sure that whether we're talking about storing CO2 in the ocean or soils or forests, we need to make sure that that research is overseen by competent environmental regulatory authorities, right, to really mitigate the potential impacts of research itself, and also provide a place for potentially affected communities to be able to have a place to weigh in during that permitting process. So we're trying to find the way through this tension, but recognizing that that we should be looking at CDR as a category as a whole.
Great, thank you, John. So we're going to do maybe another round or two of questions for our panelists here, but if audience members have questions for them or comments they'd like to make, you can drop them in the chat or in the Q&A box. Lena, coming back to you, I have had the pleasure of hearing you speak about governance of mCDR a few times now, and I often hear you say that the London Convention and Protocol reflects a very sort of technocratic approach to governance. So I wonder if you could explain what that means and what the implications are for mCDR.
Yes, thank you, Romani. So in a recent paper that we published, we kind of showcased how governance challenges of mCDR touch upon different dimensions. And that is the social dimensions, that's the ecological dimension, and the technological dimension. And we found in literature analysis that many of the most persistent challenges to mCDR governance lie within the social domain, and particularly how the social domain interacts with the ecological and technological system. So examples include who decides what is an acceptable risk, who is affected by negative implications, but also who benefits from potential carbon credits that might be derived from mCDR activities, and whose expertise counts in decision making. And these are the dimensions that tend to fall outside of the LCLP's current technocratic framing. And by technocratic, I mean that you kind of showcased this, Romani, in the Ocean Fertilization Assessment Framework. Decisions are largely made through these expert-driven assessments of environmental risk, framed around whether or not an activity can avoid harm to the marine environment in a very binary manner. And that's, of course, appropriate given really the makeup of the LCLP and the origin of the treaty as a pollution control treaty, but it is also quite a narrow governance logic. I would describe it as that because it can create this false sense that once the environmental risk of mCDR is managed, that deployment is automatically acceptable. And that may make the LCLP less relevant in the long term when trying to govern these very complex interdependent challenges that are also linked to mCDR beyond just what is the impact on the environment. And thereby, LCLP also risks reproducing these asymmetries that we do see within the UN system of emerging governance that's privileging scientific knowledge over a diverse knowledge system, and reinforcing those global north leadership in agenda setting, which is also something that we observe within the LCLP, and then sidelining discussions about distributive impacts or consent that are really important as part of the discourse around mCDR.
Yeah, great. So tying back into John's point about the need to involve communities in decision making around these projects, but there not being a lot of opportunities to do that in this very sort of this regime that really emphasizes scientific expertise above all else. So Corey, I want to ask you a question about, as I said in my presentation, mCDR is not the only sort of climate-related activity that the parties to the London Convention and Protocol have considered and sought to regulate. They've also, of course, looked at sub-seabed carbon storage and adopted a number of, at least in the London Protocol context, adopted a number of amendments to facilitate that. What lessons might there be for mCDR that parties can take from the history of that sub-seabed carbon sequestration governance?
Yeah, thanks, Romani. We just published a blog precisely on this topic, so some more there if you want to read deeper analysis. But in that blog, we sort of had 4 takeaways for the lessons that parties can learn from that history of sub-sequestration governance. The first is that it's possible within these treaties to both pursue climate mitigation governance and local environmental protection governance. We see an effort to do that within sub-seabed sequestration governance, in the way that the amendments were facilitative of these projects going forward, but also built in a framework to prevent from environmental harm from those projects. The second takeaway point is that the parties really can move quickly when the issue is urgent. From the first time parties meaningfully engaged with sub-seabed sequestration governance in 2004, they already had 2 amendments passed by 2009. So that's within international law an incredibly quick time, maybe not within other governance frameworks. The third point is that parties can and should engage across different treaty bodies when governing these types of techniques. There was a really distinct effort to engage with the OSPAR Convention and multiple references to the need to coordinate with the UNFCCC and the climate change framework there. And then the final takeaway point here is that parties can and should develop an assessment framework for mCDR activities that takes into account climate mitigation potential alongside local environmental harm. And I think we see that in the assessment framework that's applied to sub-seabed sequestration permitting activities.
So lots of potential lessons from the history of sub-seabed carbon storage regulation that might be applicable in the mCDR context. John, I want to ask you about a different set of lessons learned. So you mentioned at the outset that before rejoining EDF, you worked at the White House in the Office of Science and Technology Policy as the US government was developing its national mCDR research strategy. Are there lessons from that sort of national experience that might be transferable to the international realm in the context of the London Convention and Protocol?
Sure. Thanks, Romney. So I think there are a few lessons here. Like I mentioned, we built this team across more than 17 agencies of the US government, and we had people coming from many different areas of expertise. And we had really robust discussions. And we found that it was tremendously valuable when you bring together climate experts, people in ocean policy and other environmental policy areas to be able to explore the intersection of these areas of climate mitigation and environmental protection. So first of all, we talked about, how much CDR do we really need? We need to make a push for the biggest reductions in emissions that we can, because that will obviously reduce the amount of CDR we need, but how much do we really need? How much are we really talking about? How do we prioritize research funding, which is limited toward the most promising CDR approaches, CDR generally? How does marine CDR stack up against these other potential CDR options? What kind of standards, for credits must there be so governments and investors know how to compare the risks of one type of CDR against another? We should be prioritizing the most beneficial and the least harmful CDR methods generally. How are we regulating CDR research comparatively across all the different types of CDR? So we talked about this in terms of marine CDR in our group, but the same is true across CDR types. You don't want, since we don't really know what the best types of CDR are yet, and many are still being developed and tested, you don't want one type of CDR to sort of advance and be locked in just because it's easiest to permit, right? If it's not the best approach overall. So we need to be able to step back and compare across the board and see how we're regulating these different types. And that takes conversations across people who are familiar with soil carbon, forest carbon, ocean carbon, things like that. And then finally, how do we involve communities? This is very, very new. The field is advancing incredibly rapidly. And communities, don't really know that much about this yet. And so to be able to build relationships with communities, to be able to provide trust so you can actually communicate on these things and share knowledge, it takes a lot of effort. While we're in this research phase, it's the ideal time to be able to invite communities in so we can learn side by side about these issues.
Yeah, real challenge given how new the field is and how little people know about it. I want to ask maybe a couple of audience questions now. Libby posed a great question about the intersections between the London Convention and Protocol and the new agreement under UNCLOS on biodiversity beyond national jurisdiction and how we might think about interactions between them. The BB&J actually does many of the things that you all have been saying should be done here. It includes really robust provisions around environmental impact assessment that look beyond just environmental impacts to social and cultural impacts as well. It includes references to the need to involve diverse knowledge sets, Indigenous knowledge, community knowledge, others, and has a bunch of other things in it that could be relevant here. Any thoughts on the interactions and intersections between the BB&J and the London Convention and Protocol?
Maybe I'll just hop in quickly here with a point about the need for integration and harmonization across different treaty regimes. So like as you laid out, Romani, there's really key provisions within BB&J around environmental impact assessments and how those frameworks might be applied to activities on the high seas. And as London Convention, London Protocol parties are grappling with how to apply these EIA frameworks to mCDR activities, I think there's real lessons that can draw from the specificity of the BB&J Treaty and this sort of balancing framework that it sets up. And as the International Court of Justice and the International Tribunal of the Law of the Sea advisory opinions on climate change tell us countries need to take their treaty obligations within other treaties like the BB&J into account when regulating climate relevant activities. So really incorporating that isn't just like sort of a recommendation that would be a good idea. It's also a part of countries' obligations to uphold their responses, their internationally mandated responses to climate change.
Yeah, I think the need for harmonization and coordination across the regimes is really a key point here. In the context of the BB&J, I would say that it's somewhat challenging because the BB&J includes a number of provisions that basically say that in implementing the BB&J, parties must be careful not to sort of step into areas that are within the competency of other international regimes. And so I think that there is a potential that the parties to the BB&J will sort of take a hands-off approach to mCDR so as not to encroach onto a topic that is seen as being very firmly within the LCLP sort of competency. That will be a very interesting issue to watch as the BB&J is implemented. And I will put in a quick plug that we have a paper coming out real soon that looks specifically at how the BB&J will apply to mCDR. Another question, a few questions in the chat. How do we think about, Greg Rao has a great question here about how we think about scale in the context of governance. The approach that's been taken under the London Convention and Protocol in terms of defining what counts as legitimate scientific research actually doesn't have any stated size threshold for a research project. Do we need that? Could we design governance frameworks that are sort of different for different scales of projects? How do you all sort of think about that in this context? I don't know. John, maybe you have some thoughts on this?
We talked about this in the context of developing the U.S. research strategy, and found that it was really hard to think about, like, is there some cutoff in scale, right? And so it really came down to this question of what are the research needs? What are the scientific questions that need to be answered? You shouldn't have a field trial. I mean, if you can answer those questions in the lab or with modeling or things like that, let's try to do that first. Let's minimize potential risk of impact. But if you need a field trial and you need a field trial to answer those questions, it shouldn't be larger than you need to answer that question. It also shouldn't be smaller than is what's really needed to answer that question. So we felt like scale was should be at this stage hinged on what question do we really need to answer?
Great. Anyone else want to weigh in on this question of scale and designing regimes for different scales of operation? I think there is an inherent complexity in thinking about where to draw those lines, and even more generally in thinking about how to distinguish between research and deployment. It's an increasingly fuzzy line, particularly in the mCDR space, where we do see a lot of private sector entities advancing research, and so the dividing line between the two is very challenging. There is a question here about how mCDR is proceeding at the national level, and if there are countries that seem more sort of supportive of mCDR, that perhaps have better frameworks in place for governing mCDR. Anyone want to share some thoughts on that? I will say, I think in the past, as John alluded to, the US has done great work in this space, seeking to develop a strategy and supporting research in the field. Recently, we have seen somewhat of a step back at the US federal level in that regard, but we continue to see other countries moving forward. Canada has a large CDR program and is doing a large amount of work on mCDR specifically. Australia has a number of active mCDR research projects. New Zealand as well, I believe. And Lena, you mentioned some of the research activity that's happening in Europe, where there has been a number of projects, both funded, I think, by the German government and then also at the EU level. Don't know if you want to say anything about those.
Yeah, thanks, Romani. I think there are a lot of projects coming up right now. Even ocean fertilization is still considered, even though we see that from 2007, 2013, there was contempt for ocean fertilization in itself, and now it does seem to be up and coming again. So it's interesting also to see what are the trends, where do projects go, where does the funding go as well. I believe that, yeah, national jurisdiction is very important here. As you said, the LCLP is put into practice on the national level. And I know from the German case study that there are challenges to researching in German waters, and that German research institutions do research maybe off the coast of a Spanish island rather than in the German waters that are maybe more restricted than others.
Yeah, there's both the sort of national level regulation and the variation we see across national regulations around these activities does create some risks that we see this kind of race to the bottom with people looking for the least restrictive places in which to operate. Okay, so maybe we only have 5 minutes left, so maybe I'll just pose a general question to you all to close us out here. And that is, if there are additional lessons that the parties to the London Convention and Protocol can learn from other international treaty regimes, and how countries can think about upholding their obligations or their commitments across multiple treaties when governing mCDR activities. And so, Corey, maybe we can start with you, and then we'll go quickly to Lena and to John. Close out here.
Yeah, sure. So maybe I'll just reiterate a bit of a point that I was just making in my last comments around the international legal rules or on the requirements to really engage across treaty regimes when dealing with climate change. I think there's really strong language in the recent advisory opinions on the requirements for countries to do that. In terms of how they do that, I think there's a lot of room for parties to figure out how that is done and how that might be done well. There's a bunch of references within the London Convention and Protocol meeting documents around the need to engage with the UNFCCC and the climate treaties. And I don't know that we've seen really a robust engagement beyond that sort of speaking to the need to do it. So I think that this language that comes from international legal guidelines on the requirements to do that can really spur that type of deliberative cross-treaty consideration. There's also like an issue of siloing of delegations that go to these different treaty bodies. So one delegation might go to the Paris Agreement and a different one goes to the London Convention, and there's not really cross dialogue across those delegations. And I think we really see a need for that to happen in order to ensure that countries are upholding their obligations consistently across different treaty regimes.
Great, thank you. Lena, you want to weigh in on this?
Yes, and I'd like to build on what I said earlier and also what Corey said, that I think the ocean governance framework, the global ocean governance framework, is always seen as this fragmented, big, large, fragmented horrendogram, as it's called in one paper. And I think there's a way for the LCLP to really strengthen its environmental integrity node within that network of governance frameworks and flip that fragmentation to just a really robust polycentric system of governance. But to do that, there's definitely things missing right now. There's a missing common definitions and assessment languages across the frameworks, and we would need cross-reference of principles in the UNFCCC or the CBD, and especially to foster dialogues between those scientific bodies, between GISAM, between IPCC and IPBES, to align their assessment methodologies of these activities so that LCLP could be a connector to these different regimes rather than the silo as it may be right now.
Great, thanks. And John?
Yeah, I think that I'd like to echo some of these points. I think that really countries need to answer the question, why? Why are we doing this? So as you mentioned, Ramani, the amendments and the protocol itself hasn't generated that as many signatories and acceptances as needed. I think that if there were greater alignment between, say, the UNFCCC and LCLP, if there were greater alignment about here's what we really need to solve the climate crisis, here is how CDR fits into that, here's how marine CDR could fit into that, then if there's alignment around why we need to be doing this research, why we need a regime to oversee the research, and how we should be thinking or anticipating deployment down the road, then I think that you'd have countries more interested in like trying to figure out how do we best effectuate that. So to Corey's point, I think that the policy people and for climate and oceans haven't really been talking, but the more that happens, the more they start getting to this question of why are we doing this, and then how. So that's what I would say is let's focus on the why and let's get people aligned around that.
Great. Well, a lot of work to do, and it will be very interesting to see the discussions at the upcoming London Convention and Protocol as the parties continue to engage on these topics. I want to thank our panelists. You were all amazing. For those who are in the audience, thanks for sticking with us. We are going to post a recording of this webinar on the Sabin Center's YouTube channel, likely next week. So if you missed anything or you want to see it all again, you can do that. But thanks, everybody. We appreciate you joining us.